Right now, we're in the countdown phase to one of the biggest Second Amendment cases since Bruen. On January 20th, 2026, the Supreme Court is scheduled to hear oral argument in Wolford v. Lopez, a challenge to Hawaii's 2023 law that flips the default on carrying a handgun onto private property open to the public. Under that law, your permit isn't enough. You're presumed to be breaking the law unless each owner gives clear permission for firearms. The justices have limited the case to that key question, and the Trump Justice Department has already filed a brief supporting the challenge and asked to argue. In this video, I'll bring you up to speed on how we got here, what exactly the Supreme Court is being asked to decide, and how the ruling expected later this term could shape carry rights far beyond the islands. Let's start with what Hawaii actually did, because the details here matter. Following the Supreme Court's decision in Bruen, the state passed a new law, Act 52, which reshaped the rules governing who can carry and where. On paper, the state moved from a may-issue permit system to a shall-issue system, meaning ordinary people who meet the requirements can get a carry license. But tucked inside that same law is the rule at the heart of Wolford v. Lopez. On most private property that is open to the public, gas stations, grocery stores, malls, restaurants, a licensed citizen is presumed to be breaking the law if they carry a handgun unless the owner clearly says yes to firearms. Under Act 52, the default is flipped. The old understanding in most of the country is simple. You can carry on private property unless the owner posts a no-gun sign or personally tells you not to. Hawaii did the opposite. Now, unless the owner gives express permission, either in writing, with a sign, or face-to-face, you are legally treated as if you are trespassing with a firearm. No sign is required to keep you out. So for a regular permit holder trying to live a normal day, that means every doorway you walk through becomes a legal question. Did this owner explicitly invite firearms, or are you automatically in the wrong the moment you step inside? That is why this case is not just a fight over theory. It is about whether a carry permit in Hawaii is still a practical tool for self-defense, or just a piece of paper that only works in a shrinking list of places. The whole point of this challenge is to ask whether a state can comply with Bruen on the surface, then turn around and use default rules to make real-world carry almost impossible. Now that we have the basic rule in view, let's talk about how this case worked its way up to the Supreme Court. Not long after Act 52 took effect, a group of plaintiffs, including everyday citizens and gun rights organizations, filed suit in federal court. They argued that the new law, including this private property default, violated their right to carry a handgun for self-defense in public. The case ended up in front of a federal district judge in Hawaii, who had to decide whether to let the law go into full effect while the lawsuit moved forward. At that early stage, the district court agreed with the challengers on some key points. The judge issued a preliminary injunction that blocked the state from enforcing parts of Act 52, including the rule that made most private property off-limits by default. The court essentially said, "We need to hit pause on this while we look more closely at whether it fits with the Second Amendment and the history the Supreme Court talked about in Bruen." For a while, that meant permit holders in Hawaii were not under this flipped default everywhere they went. The state of Hawaii was not happy with that result, and they appealed to the Ninth Circuit Court of Appeals. That is the federal appeals court that covers the western states, including Hawaii and California. A three-judge panel on the Ninth Circuit took a fresh look at the district court's decision. In that review, the panel kept some parts of the injunction but reversed others. On the issue we are focused on today, the default rule for private property open to the public, the panel sided with the state. They allowed Hawaii to enforce the provision that treats private businesses as gun-free by default unless the owner opts in. After that, the challengers asked the full Ninth Circuit to rehear the case, a step called en banc review. That request was denied. With the default rule back in force and the local appeals court signaling that it was comfortable with Act 52 on this point, the plaintiffs had one place left to go, the United States Supreme Court. They filed a petition asking the justices to step in and decide whether a state can flip the presumption on such a broad swath of private property and still claim to be respecting the right to carry that the court recognized in Bruen. The justices do not have to take most cases that are sent to them, and often they choose not to. In this instance, they did something different. The Supreme Court agreed to hear Wolford v. Lopez, but with a very specific focus. They narrowed the case down to that one core question. Can a state presumptively ban licensed citizens from carrying handguns on private property open to the public unless the owner clearly authorizes it? In other words, is this kind of default compatible with the Second Amendment, or is it a clever way to get around it? That alone would make this a major case, but there is another piece that surprised a lot of people: the role of the United States Department of Justice. When you hear DOJ in gun cases, you might think of the government defending regulations and arguing for more restrictions. In this case, under the current Trump administration, the Department of Justice has stepped in on the side of the challengers. They filed a friend of the court brief telling the Supreme Court that Hawaii's default rule goes too far. In plain language, the Department of Justice is arguing that when a state flips the default in this way, it is not just regulating the time, place, and manner of carry. It is functionally erasing the right in the very spaces where people live their lives: stores, gas stations, restaurants, and other everyday locations. The brief points out that property owners already have tools to keep guns out if they truly want to. They can post a sign, adopt clear policies, or tell someone to leave. What Hawaii has done, according to DOJ, is something very different. They have turned almost every private business into a no-carry zone unless the owner goes out of their way to say otherwise. On top of that, the Department of Justice has asked the Supreme Court for time at oral argument. They have requested a slice of the challenger's time so that a government lawyer can stand up in that courtroom and speak directly in favor of striking down Hawaii's default rule. That is not something you see every day in a Second Amendment case, and it sends a strong signal that, in the government's view, this is not a close call. It is a line that should not be crossed. Of course, Hawaii tells a very different story about what it is trying to do. The state argues that Act 52 is about public safety and about respecting the rights of property owners who may not want firearms on their land. They point to a long history of laws controlling where weapons can be carried and say their modern list of off-limits locations fits within that tradition. In their view, allowing owners to opt in to guns instead of forcing them to opt out is just another way of balancing safety, property rights, and the right to carry. The Ninth Circuit largely accepted that framing when it allowed the default rule to go back into effect. The panel said, in essence, that this kind of restriction might touch the Second Amendment, but it could still be justified when you look at history and tradition. That is exactly the point of tension that now sits in front of the Supreme Court. One side sees a neutral safety rule that leaves choices with property owners. The other side sees a structural move that turns a recognized right into something you can almost never exercise in ordinary public life. And this is where the case stops being just a Hawaii problem. Other states have already borrowed similar ideas. Places like New York, New Jersey, and California have all experimented with laws that treat most private businesses as gun-free zones, unless the owner posts a sign or gives special permission. Lawmakers in those states watched what happened after Bruen and tried to redraw the map of sensitive places and defaults in ways that keep licensed carry as rare as possible. What happens in Wolford versus Lopez will send a message to all of them. If the Supreme Court upholds Hawaii's default rule, you can expect these experiments to spread and harden. More states will feel confident flipping the presumption, and more permit holders will find that their license does not cover the places they actually go. If, on the other hand, the court strikes down this kind of default, it will put real limits on how far states can go in turning everyday locations into invisible gun-free zones. It will not answer every question, but it will close off one of the main strategies that has been used to sidestep Bruen. For you as a viewer, the key takeaway is this: even if you do not live in Hawaii, this case is worth paying attention to. It is about whether a right the Supreme Court has already recognized can be hollowed out through clever rules that sound neutral, but operate like a near ban. As the justices hear arguments and move toward a decision later in the term, this case will help define what public carry really means in practice, not just on paper. So that's where Wolford vs. Lopez stands right now. Hawaii's flipped default is live, the Supreme Court is set to hear arguments, and even the Department of Justice is telling the justices this law goes too far. We do not have a ruling yet, but whatever the court decides is going to echo far beyond one state. I'll keep tracking every filing and every development for you. If you want to stay ahead of these 2A cases, make sure you like this video, subscribe, turn on the notification bell, and never forget, this nation was built and will be maintained by armed scholars.